witnesses in the... With regard to one of the aggravated assaults. Aggravated assault. It's not a motion per se.
My name is Brandon.
No, not for this. With regard to...
Clark, where are you?
With regard to aggravated assault number at 832288, where Robert Lawson is the affiant, after speaking with the officer today, the state and Officer Lawson believe that we cannot move forward with this, as Officer Lawson was not present at the time the defendant was pointing the gun. It was the other officer. I believe he would have to be present in order for him to be in fear of that weapon, and so we're going to dismiss that charge. We are ready to go on the criminal trespass and the aggravated assault.
Mr. Clark, warrant number 832288, traffic value assault, was announced and put into the road by the 58 General Lane. Case is dismissed. On the criminal trespass first.
We are, Judge.
Procedure.
Also, Judge, if you will note, this morning there were stipulations made. One of the stipulations which has been provided to the court, and we're going to be referring to with Lieutenant Reynolds' testimony. That's going to be the emails. So if you wanted to direct those to your attention. Well, just go ahead and set that aside. Yeah, that's okay. We do have no further objection, but it's a state's requirement today to prove that this gentleman was in personal communication told not to go back on UT property. We are certainly not, especially at a juncture preliminary hearing, required to prove exactly why the university felt it necessary that he not go on their property. There may be a form for such exploration, but it's not today.
And I'm not getting into that, Your Honor. The statute requires a personal communication from a person with a parent. It's relevant because, Your Honor, you're supposed to exclude from this determination of probable cause any illegally obtained evidence. This is pertinent for the second case where we are alleging this warrant is invalid. So if the warrant's invalid, the officers could not have broken into Mr. Clark's house, and all the evidence that they observed should be suppressed. And I don't doubt that.
My objection is he's asking this officer with regard to did he call, this lady call, did this person call, did this person call. This is still fine on the criminal trespass warrant. I think all the other questions that he's referring to are relevant for that purpose. Beyond that, I believe that she's
getting into both.
Actually, how any of this goes, and I don't know how this how this goes for the probable cause, or even the relevancy at any point in time with regard to this officer getting a warrant for criminal trespass against this gentleman.
Your Honor, if this warrant is invalid, none of the evidence of these deputies on April 17th should come in at all. That's the only reason they had to kick down the door, the only authority they had to kick down.
And I'm sure you'll make that determination to close this proof, but this is not relevant to that. It doesn't go to that.
Of course it does. Well, okay, for example, this...
You just made I know that that's fine. I just want to remind the court that at some point in time, this is a witness that was originally subpoenaed by the state, has been subpoenaed by the defense, of course, he's going to start subpoenaing witnesses, but he doesn't have the right to call every state witness that there is.
This is my only witness.
No objection.